Could you maybe elaborate a bit more how far do you think, if you can, if you could, that the judges could go, and what is the limit of that interpretation?
As the Rome Statute states expressly that the literal interpretation must be adopted when interpreting the elements of crime, but obviously observing the case law of ICC, we could see some fragile point of this literal interpretation. I mean, when it comes to the features of crime, which are not properly elaborated under the statute and elements of crime. So could you see the limits for activism of judges of the court when it comes to the elaboration of elements of crimes?
In fact, concerning the interpretation, what is not easy to understand for international lawyers. In fact, this is this hierarchical structure in Article 21 as such. Nevertheless, apparently the drafting fathers or founding fathers wanted to do this because they considered that the strict interpretation of the law is important in order to preserve the procedural rights of the indictees. And so that's why to punish per analogiam should be rejected on the basis of different historical experiences of the Nazism, of the Stalinism as such. And so that's why they set up this special structure of Article 21, that on the first place Rome Statute elements of crimes and rule of process and evidences, and on the second place when appropriate other international treaties and customs. And the issue is, of course, when this is really appropriate and necessary. And in fact, this was, by the way, also behind the problematic of the decision about Palestine as such, where in fact two fellow judges arrived to the other position than I arrived at. And there really the issue was that there was such a jurisprudential decision elaborated some years ago, maybe in the one of the Lubanga and Katanga decisions. So in 2008, that the judge can refer to another international treaty only in case of a clear lacuna within the Rome Statute. Once again, the issue is whether this clear lacuna concern the individual liability issues or some other aspects can be done. By the way, later, you can find that in my dissent, there were some decisions where this clear lacuna concept was a bit reinterpreted by one of the chambers as such. And in fact, this is, I guess, always, so we cannot say in clear terms what does it mean. There is a lacuna or whether there is not a clear lacuna. And in fact, in Article 21, there is, however, an exception concerning the Human Rights Conventions. And so that's why, once again, we have to pass a decision whether we are thinking in terms of Article 21 A, paragraph 1 B, or paragraph 3. Yeah, with the Human Rights Conventions as such. And in fact, so in the Palestine situation decision, there were so many other issues which were covered, which were there in my mind. I mean, the legal nature of the Oslo Accords, Security Council resolutions and so on, or the same, some related problems emerged also in the Myanmar Rohingya decision, when we had to interpret the Rome Statute itself, and where we also used some international conventions as such. And by the way, whether we can use the Vienna Convention, it's a must. So that there is no doubt about it. It was always mentioned by the different chambers. What is really important is that to preserve the cohesion of the jurisprudence as such. And sorry, I don't say that I can see too much clarity about the differences when we can go to the activism, when we can go through the threshold of the activism, and when we are still not there. I guess that generally, and anyway, especially concerning the procedural rights, it's sure that there we are ultra-conservative as such. By the way, I mentioned the jurisprudential invention of the indirect co-perpetration in the Katanga case, and this was heavily criticized by one of my fellow judges, Madame Christine van Weingert from Belgium, telling that, well, this is something which ran against this strict interpretation rule, where, by the way, the given trial chamber referred to the jurisprudence of the European Court of Human Rights, also to a Hungarian case, the Dalos versus Hungary, where this was first done or admitted by the European Court of Human Rights, that these can be, in fact, referred under some conditions. Yeah, so this is compatible with the European jurisprudence, according to our perception.
My name is Rutvica Rusa-Novokmet, and I'm from the University of Zagreb, from Public International Law Chair. So maybe a question for Professor Adanyi. You mentioned that the International Criminal Court sometimes needs to discuss and decide on certain public international law issues. So my question is, maybe to refer also to the practice of ICT, why that needed to explain, for example, the prerequisites of the existence of international or non-international armed conflicts when deciding on individual criminal responsibility. So how does the ICC explain this expanded task to discuss some other international law issues? Does it explain its role? Is it only the necessity of discussing these issues before determining the individual criminal responsibility?
Thank you so much. It's a great question. I would like to ask it from myself too. First thing that comes to mind as a way toward the answer is the structure of the ICC. List A and list B of the judges. So we have half of the judges are criminal lawyers and half of them are international lawyers. And I think it was perceived at the very beginning that these issues will come up. So structurally speaking, the ICC is prepared, is designed to answer these questions. Of course, the mandate is clear that the mandate is much more limited than the structure suggests. So at this point, I would say, I don't have any evidence right out of my mind, but I'd say that may lead us to the question of implied powers. So that the drafters of the Rome Statute actually foresaw that these issues are going to come up. They gave a limited mandate. They gave a simple spade to dig a hole for the ICC in the mandate, while in the structure they gave excavated. And yes, the particular example that you referred about, the distinction between armed conflict types, is really a very good example to see why it is so controversial to do it. And I know that in the literature there are pieces which ask whether ICTY started to humanize too much international criminal law, which is an understandable trait. But structurally speaking, the issues I have been touching upon were more related to the core, more technical issues of international law. And I think the answer is very simply, at what I have read, the language suggests of the public materials that the ICC was not doing this in an activist way. They could have said much more. Sometimes you feel the restraint. You know, we are professors, and some of the judges are also professors. So when you read the text, you see that, like, they forcibly stopped here, and leave the conclusions to the reader, because these are there, like the Palestine situation, explaining that no, we are not deciding on statehood. I think this is the best I can give you as an answer. I hope it suffices. Thank you.
So one question triggers another one, and my question is very straightforward. How do you think the ICC can avoid the politicization? Because that's the word that you mentioned, actually. Because they are professors, they are judges, and they don't want to talk about politics. But we know that politics, at the end of the day, is the one that is above, even, unfortunately, some legal questions. So how can the ICC avoid that one? And my second question is for you personally, Mr. Adani. Do you think the ICC should also evolve in terms of jurisdictions? For example, should it take also problems dealing with eco-state, for example, environmental crimes, and maybe piracy, even if it is not anymore that popular like 10 years ago? But do you think there can be, must be, or shouldn't be any evolution? And to all the audiences, the last question is, what do you think, if you have time, of course, what do you think is the future of ICC in Africa? Do you see it as a complementary work, or just the ICC? Because there are others chambers in Africa dealing with fighting crime, and I will talk about that tomorrow. But anyway, according to you, what do you think is the future of ICC in Africa?
There were three questions. ICC future in Africa, about subject matter jurisdiction, and the first one was just politicization. Okay, I'm going to be very brief and very honest on all three. First, politicization. I don't think that the ICC as an institution can avoid politicization. Because it's a part of international law, and international law is to some extent touched by politics as any application of the law. But I think politics, and I think I'm in the mainstream here when I say that politics should not be allowed in the courtroom. Politics should end by drawing those lines what cases end up in the courtroom. And it's definitely not the same. From that point on, it should be reliable criminal law. So when we reach the trial phase, there are no politics, no international issues, that's criminal law. In the pre-trial phase, there is as much politics as possible, because we are already in the courtroom. That was very honest, and I can give you the details. I hope we can have some time to catch up later. About subject matter jurisdiction, I speak strictly on my behalf. It's private opinion, and not any other organization's opinion I represent or may not. But I think that the ICC, the Rome Statute, has sufficient room at this moment to include most of these crimes when they pass the necessary threshold, environmental crimes included. Under Article 7(1)K, for example, and other inhuman acts, that was pretty much designed as a filter to include all of this if they reach the threshold. So I think there are no need for inclusion of new crimes at this moment. And about the ICC's role in Africa, I'm eagerly waiting your tomorrow's presentation. And one of the questions that haunts me is how would complementarity be understood when it's not understood between a national court and the ICC, but an other international court and the ICC? I have some clues in the statute. I think the other international court would be considered as mutatis mutandis, as a national court, with something else in mind, like the Srebrenica genocide had been treated by the ICTY and the ICJ decisions, that the other court's opinion is not res judicata, but it's decided because it was tested by a high-quality judicial standard. The findings of that other court are considered the wording was something like highly persuasive value. So it's going to be a very strong evidence. These are the lines that I can offer for further discussions.
I said the word about the politicization, that we have 20,000 situations submitted to the preliminary investigation and just 1,000 cases before the court and 3 by convictions. So
my name is Abela and I'm counsel within the Office of Public Counsel for Victims before the ICC. And I was actually the one to request that former child soldiers would be recognized as victims of war crimes when maintained in sexual slavery. Now, I don't know exactly what the controversy is about because you didn't develop, but I'm afraid it will lead to what the defense was arguing and leaving these girls without any protection from being raped days after days. So that's my contribution to this controversy.
One question for Professor Varga. You talked about the problem of war crimes as a customary international law, and that the judges don't like to apply something that is international customary law. So my question is the Hungarian Constitutional Court authorized to somehow instruct other courts to also refer to international customary law when the cases are about war crimes? Thank you. And one short question for Professor Hoffman. Maybe something about what you think about the reasons why the codification, why the adoption of a potential treaty, Convention on Crimes Against Humanity, was not concluded, only the draft articles. Thank you.
Okay, Judge Kovacs, and then.
Thank you very much. It's not a question, a contribution to Professor Hoffman's lecture. In fact, it happened in a very strange way in the Philippine situation that we had to deal with the notion of civilian population, because there, in fact, those who were really concerned by the alleged act committed by the government and subordinated services were in fact criminals, so drug commerçants and so on and so on. But in fact, it was said by the prosecutor that, okay, this is a civilian population, there is no doubt about it. And in fact, we tried to add something in order to explain why this is not so simple. Nevertheless, we confirmed that effectively they are falling under the notion of civilian population, I mean the drug traders and so on.
Okay, thank you. And I saw one, yes.
Hi, Maja Munevrana, Faculty of Law, University of Zagreb. And just as a follow-up to Rutvica's question for Professor Varga, or maybe just a comment, I'm not really sure. We were talking about applying international customary law by domestic judicial authorities. And I can only speak from Croatian perspective, but I think at least in some of the countries in the region, there was a huge problem to apply customary law as a source of law because of the formal strict requirements of principle of legality. So I was wondering if this is also seen as a problem by Hungarian judges or not, and what are your views on that? And I also have a question for Professor Hoffman. I was wondering, talking about the problems and obstacles to adopting finally the Convention on Crimes Against Humanity, you were talking about the problems with respect to definition of the crime. And I was wondering, what do you think of compromissory clause and giving jurisdiction to the ICJ? Do you think that was also a problem? And to solve disputes similarly to what we have today with the Genocide Convention, and that would perhaps take off the pressure from states to try to subsume certain facts under the notion of genocide, which we know is very difficult.
Thank you very much. And let's hear the answers. Please try to formulate your answers as briefly as possible.
Okay, so first of all about the codification of crimes against humanity. So very quickly, so first of all, I think there is a general problem with codification in the past few years. I mean, states just don't want to adopt major new treaties, especially when they potentially impact their national interests. So I'm probably very pessimistic, but I don't think that the Genocide Convention could be adopted today. I mean, of course, it could be adopted in 1948, and something like the compromissory clause, I mean, no way states would accept that. So especially now that we see that the ICJ has kind of reinterpreted its approach to erga omnes and jurisdiction, and now relying on the Genocide Convention, I mean, states can initiate proceedings. So I don't think states would want to try that. So I think a compromissory clause is definitely a problem. It's not a solution. So I don't really have any better answer than the states are generally very, very aware of adopting major new international treaties that could potentially impact their international status and standing. So that's why I think the Crimes Against Humanity Convention is kind of moribund. So well, it's unfortunate, but of course we still have Article 7, which seems like custom, at least by most countries. And then just very briefly come back to because I didn't have time to explain my standing when it comes to civilian population. Now, we have a lot of jurisprudence from different international courts which kind of try to avoid this problem by reinterpreting the concept of civilian population. For example, even the ICTY and the extraordinary chambers for Cambodia said that, well, civilian population requirement is just a jurisdictional requirement. So if we have jurisdiction, then we don't have to apply it. Now, one might say that, well, I mean, from legal dogmatics point of view, this is not satisfactory. But, I mean, to be blunt, I think judges can reinterpret the statute very, very easily if they want to. We've seen that over and over and over and over again in the history of international criminal law. So for me, it seems really strange that when we have a very well ingrained system of international humanitarian law, which is based on the idea that humanitarian law applies to protect others and not members of our own group, then how can we just say that now, from now on, humanitarian law applies everywhere because it's humanitarian? But of course, humanitarian law has never really been humanitarian. That's just something that the ICRC is trying to make us believe. But I'm a cynic here, so I'm sorry.
Thank you very much for both questions, which shows that we have very similar problems. Regarding the first question on whether the Constitutional Court can instruct courts to apply customary international law directly, no, it cannot. What it can do, though, is if there is a specific case, then the Constitutional Court can say or not say whether a specific legislation or now a judgment violated the Constitution or the Basic Law. And it did say, the Constitutional Court did say in the early 90s and then in forthcoming decisions, as I said, that actually if in Hungary, if a domestic judge directly applies international law, it would not be unconstitutional. But then if the judge would not, there's nothing you can do. But then the judge could feel safe based on these Constitutional Court decisions that it will not violate the Constitution. So that's so much the Constitutional Court can basically do, and it did. But still, the courts don't like it. And from the case which I mentioned, the prosecutors don't like it either, and again, there's nothing you can do. And this is why there was a kind of like need for implementation, and then this leads to your question. Again, very similar problem. It depends on your and our constitution. In our constitution, we are a dualist state, such as kind of all of us, pretty much here. Our constitution says that the general principles of international law become part of the Hungarian legal order without specific transformation. This is not exactly how it says it, but this is what it means. So in our understanding, the Constitution itself does this transformation with respect to general principles of international law, which we like to understand customary international law as well. So the Constitution does this. So it depends on how your Constitution is formulated. But even here, where we international lawyers kind of agree on this, there is a very sharp debate between international lawyers and constitutional lawyers, and I think we are starting to win, maybe, because there are more and more cases. But yes, it could be for constitutional lawyers. It's like, what is general principle of international? It's a very strange concept. So what we can do is kind of publish, and engage with constitutional lawyers, and probably when we have more cases, then these will, but we have very, very few cases. So I fully sympathize with your question. We had similar problems. Thank you.
It's a question from the intersection of criminal process, morality, and the ethics. So imagine the military conflict is over. We are the prosecutors. We managed to find the perpetrators of the crimes. They are the teenagers. They're the responsible of the death of many other teenagers. What shall we do in such a scenario? Shall we apply the justice? Shall we wait? Or maybe find another solution? How to deal with the children who are the perpetrators? Thank you.
This is tragic dilemma. I don't know, because like in World War II, we don't know what we do in this time. It is done only as abstract. In this time, I haven't answered. Maybe my colleagues, but not. This is the tragic dilemma.
In fact, it would be good to go back to one of the slides concerning Article 15 ter, when you can do that, because there, at the proprio motu issue, this is not the pretrial chamber which will give the authorization, according to the Kampala text, to a proprio motu action of the prosecutor, but the pretrial division as such. And normally, the pretrial division is composed probably of 6 people. And in fact, what will happen when there are 3 voices in favor and 3 against? We tried to find a result on that, and there were internal debates on that. But in fact, legally, what is your opinion about that? How to solve this very, very hypothetical issue that the ICC will be seized with the aggression?
Actually, it's a very hypothetical scenario, I think. There's no case law, there are no examples in practice, and frankly, I don't really see that in the foreseeable future it will ever happen and will be a real dilemma for us how to settle this situation.
Just short comment and answer connected to that debate about children who were soldiers and even perpetrators. What can be the problem? I think, I ask you about your opinion. When we are talking about children or juvenile who commit the crime, they are children and juvenile in the time when the crime is committed, but there is no statute of limitation. And for example, that child in the time of the crime or juvenile can be in the time of a trial probably 70 years old or even more. We have example from the Germany, I think 2 years ago, one person who was probably guard in the KZ camp was convicted as juvenile on juvenile prison, although he was very old man in the time when he was convicted.
I am very fond to the tribunals in this case, the child soldier, to establish the solo tribunal ad hoc. Maybe this with these special rules of, for example, juvenile, I don't know, and the separately than the ICC. In my opinion, I studied the Court of Sierra Leone, and in my opinion, it is very effectively tribunal. For example, to defendant, to the accuser, and the rules is very clarity. And maybe it is the way that the compose, the create, separate rules. To the devoted, to the accountable, to the child soldier. Maybe rules and separately tribunal ad hoc. You know.
Dear Professor, what is your opinion about international law having two subsets, namely human rights law and international criminal law, who are defining the age of minority a bit differently? Because in the 1989 New York Convention, that age limit is 18, and that is what several agencies, several UN specialized agencies even, and NGOs are pushing as it would be desirable. Whereas for the Special Court of Sierra Leone, for example, they're saying that child soldier is around 15 or at least shouldn't be lower than 15. That's right, and I do understand that we are sort of tolerating certain state practices, whereas they are drafting young adults of 16 and 17. But do you see a change in state practice in which this heightened protection can be improved or can be extended to reach this age limit of 18? So what are the current tendencies that can be observed currently?
In my opinion, high age is the best. Too high is the better, and the age of the children. We answer about this question is like the convention of the law, child law, and in this there is 18, if I could remember, and in this, in my opinion, this level is good. But I don't to upper to this.
So states are willing to amend their own laws to be in conformity with the New York Convention?
Yeah. Yes.
Even regarding child soldiers?
Yes.